First matter to come before the court this morning is State of Ohio versus Jacob Powers. Both sides will have 15 minutes to present oral argument. The appellant may reserve up to 5 minutes for rebuttal. If you're the appellant and wish to reserve that time, if you let me know when we get started, it helps me let you know if you're running into or over that time. As you can see, we do have the clock, so you can keep track of the time yourself on the screen up there. Please do not use the names of any victims or minors in your oral argument presentation, as we are going to be posting this oral argument on the court's YouTube channel. We have read the briefs and we are ready to see who you are.
Your Honor's opposing counsel, may it please the court, Attorney Angie Killey on behalf of the appellant Jacob Powers, and I would like to reserve 5 minutes for rebuttal, please.
Thank you, counsel.
Your Honor, the first question presented for this court today is whether or not the court abused its discretion when it denied appellant's motion to dismiss for lack of subject matter jurisdiction. As I'm sure the court is aware from reviewing the record and the briefs, there is a long procedural history in this case, and that procedural history is the vast majority of what is at issue on appeal today. And part of the issue is whether or not Mr. Powers was in fact a child or an adult pursuant to law at the time that he was actually charged with this offense. While generally abuse of discretion is the standard for a motion to dismiss, this one, since it is a question of law and subject matter jurisdiction, is actually a de novo review. We're talking about 4 case numbers essentially, and what it boils down to is that Jacob was charged in juvenile court within days of his 21st birthday. It was dismissed voluntarily by the state. It was indicted in common pleas court. Jacob was arrested, held in jail, ultimately dismissed at the request of the state again in the common pleas court, transferred back to juvenile court when he was 22 years old. And there was a challenge to that jurisdiction. Now, at that time, obviously, he was past the age of jurisdiction for juvenile court when that case came up. And I believe that what Judge Teodosio ultimately ruled on was that she had jurisdiction because of the first case. However, we believe that that is error on her part. Like, if you look at the statutes, the question becomes whether or not he is a child under law. And what the statute says in 215202 is that he's under 18 at the act, but not taken into custody or apprehended until after 21 years old. So in this particular instance, because it was a new case number, although be it the same charge, Jacob was not arrested and charged in this second case number in juvenile court until he was 22 years old. His date of birth is 11/13 of 98, and that complaint was filed on 6/3 of 20. So we believe that the court was in error on that, and that this exception to the statute that normally finds that someone is a child as long as the act was committed, is that Jacob in fact was not a child, and therefore the conviction is void because the court lacked subject matter jurisdiction in order to actually review the entire case. I cited the Hudson case in my brief, which has a similar fact pattern, and the court then did rule that the court was divested of jurisdiction and the case should have been dismissed. The second question for the court to consider in this situation is whether the sex offender classification was unconstitutional. And I do recognize the fact that when I'm talking about 2 assignments of error in this brief, that in one instance I'm saying he's an adult, and in one instance I'm saying he's a child. But I think that's part of the problem with the way that the law is at this particular point in time. Sort of needs to be one way or another. If he's a child in one instance, he should remain a child throughout the entire proceedings. If he's an adult, he's an adult. As it relates to the sex offender classification, our argument is that it's unconstitutional as applied to Jacob, and that it's a violation of his due process. Clearly, I went through my brief. There have been a lot of courts that have analyzed this issue, and most of them finding that once the bind-over process has taken place, that individual has been afforded due process and therefore can be classified as an adult in the adult system as a sex offender for up to the rest of their lives. In this particular, I don't think any of the cases that I found are really comparable, and that's why we're doing an as-applied analysis, because first 5 of them that are in there that were analyzed in great detail are all plain error. And we're not dealing with a plain error standard here because his trial counsel did raise this issue, although the court didn't give any detailed decision on why it denied the motion. It was raised at the trial court, and in other instances too, where it was raised, those cases were all direct transfers. Like this child was perhaps 17 years old when they committed the offense, they're bound over under the law. They had their probable cause hearing, they had their amenability hearing, and the court found them to be an adult in that system. Well, in Jacob's case, we have like a 3+ year delay before he was even charged or this crime was even investigated. That's not his fault, and it's not obviously the police's fault. You know, we know that some cases they don't come to fruition until later on given the memory delay. However, in that instance, what it effectively did to Jacob is deny him that due process that most people receive in the transfer process from juvenile court. And I'm not saying that the court didn't give him the 2 hearings he's entitled to by law, but what I'm saying is that hearing number 2, particularly the amenability hearing, the determination of whether or not he is able to be restored or rehabilitated in the juvenile justice system, because this is not a mandatory transfer charge, it's discretionary. He had that hearing, but he had no opportunity to be successful there. If you review the record, the transcripts from juvenile court, Judge Teodosio said very clearly on the record on page 61 of that transcript that because of the only reason that he was being transferred to the adult system was because he was already 22 years old. The testimony that was presented and the evidence that was given through the amenability report that was provided in juvenile court said that he could have been rehabilitated in the juvenile justice system within 1 year. However, because he was already 22 years old by the time this case came up, she couldn't keep him. There's no authority in order to be able to issue orders for him to comply with to do that rehabilitation, which effectively turned it into a mandatory bind-over in our position, which is why he wasn't afforded the due process that protects other juveniles who are similarly situated.
Counsel, as to the amenability hearing issue, your opposing counsel suggests in her brief, and I have not looked at the record, but suggests that there were other factors upon which the trial court relied. Do you disagree with that? I believe one of the ones was the relationship with the victim.
I think that when the court issued a journal entry, that she kind of checked off the boxes. But if you read the transcripts, she clearly said, I cannot keep you here because of your age. So it was pretty evident that that was what the focus was.
And my second question then on the same area is, wouldn't success in terms of amenability, having more time, really be speculation on our part? I mean, who's to know, I guess is what I'm asking.
Well,
And I realize from your perspective, it's we'll never know, but isn't
Well,
that
I think-
speculation?
on that same realm, and part of it, you know, from my experience doing that kind of work, is we never know in any case. I mean, it is speculation. The legal process, though, is to have a mental health professional sit down and evaluate this child. That report, which is part of the docket from juvenile court, indicates that they believe that all of the issues that he had could have been addressed and he could have been rehabilitated within 1 year. So in most circumstances, the court would say, okay, and then give it a try. And of course, in a situation like this one, it's a huge difference. I mean, sex offender classification in juvenile court is discretionary, and it certainly doesn't last anywhere near as long. So this is some, you know, conduct from when he was in fact a child. The stigma will attach to him for the rest of his life. And I guess, I mean, you're right, in some ways, yes, we are calling for speculation, but not in any way that we aren't in every other case that there's a question of bind over or not. If there aren't any other questions, then I think I would rest.
Thank you, Counsel.
Good morning, and may it please the court. I'm Jacqueline Corrigan on behalf of the state of Ohio to urge this court to affirm Mr. Power's conviction for 2 reasons. First, the General Division did validly possess subject matter jurisdiction over Mr. Powers' case. And second, that Mr. Powers cannot show by clear and convincing evidence that any reason why this court should carve out an exception to the adult sex offender registration just for him. Regarding the first assignment of error and the question of why the General Division did validly have subject matter jurisdiction over this case, it did for two alternative reasons. First, based upon the fact that there's no real dispute in this case that Mr. Powers was considered a child when he was apprehended in 2019. He had committed his acts when he was 17. He was arrested at age 20. And so he was apprehended before he was age 21 in the 2019 delinquency case. Now, keep in mind that the juvenile court's subject matter jurisdiction is entirely constrained and established by statutes. And when it comes to deciding who's a child in circumstances like this, you look at the age of the person when they committed their offenses and the age at their apprehension. And so, like I said, there's no dispute that in 2019, when he was apprehended, Mr. Powers was a child. Now, what happened with this was, yes, the state of Ohio thought that because the juvenile court was we were coming up on Mr. Powers' 21st birthday, mistakenly thought that the juvenile court would lose jurisdiction over him the moment he turned 21. That actually is not the case. The Ohio Supreme Court has in multiple instances clarified that the subject matter jurisdiction of the juvenile court continues past age 21 unless the juvenile court properly binds over a delinquency case for criminal prosecution in the General Division. So until that proper bind over occurs, subject matter jurisdiction is not divested from the juvenile court. That's Johnson versus Sloan from 2018. In addition, the juvenile court retains its subject matter jurisdiction after age 21 to hold a bind over proceeding, and that's established by State of Ohio ex rel. NA versus Cross from 2010, and also an improper relinquishment of subject matter jurisdiction by the juvenile court means that anything that happens in the General Division is void ab initio, and even that transfer from the juvenile court without a proper bind over proceeding is itself void, and that's State versus Golfin from 1998. Now, that's essentially what happened here, is the juvenile court just allowed the dismissal of this case without a proper bind-over procedure. That was void ab initio. It did not divest the juvenile court of subject matter jurisdiction over Mr. Powers, nor did it confer jurisdiction to the General Division. Alerted of that fact by Mr. Powers' counsel, the state of Ohio agreed at the General Division. The General Division then dismissed its 2019 indictment against Mr. Powers to allow the juvenile court to proceed as it should have, which was to actually hold a proper bind-over hearing in his case. And that's what it did. And when that court held its bind-over proceeding and bound the case over to the General Division, then subject matter jurisdiction was properly conferred to the General Division, and it could proceed apace and hear Mr. Powers and accept his guilty plea. There is an alternative means, however, by which the General Division had or could have had proper subject matter jurisdiction over Mr. Powers, and that was because, considering State versus Bear and the Hudson case from the 7th District, Mr. Powers was alternatively apprehended in the 2020 criminal case once he was indicted in that case. So once that occurred, the court could have also had proper subject matter jurisdiction over him. However, either way, the General Division did have proper subject matter jurisdiction over him at his case, and therefore his conviction stands. Now, getting to his argument that adult sex offender registration ought not to apply to him based upon the facts of his case. Again, the prevailing case law is that when someone has been bound over from the juvenile court for adult prosecution, that the adult sex offender registration statutes apply to that person. So that is the weight of the statutes in the case law. When you get to an as-applied constitutional challenge of the type that Mr. Powers brings, statutes are always presumed constitutional unless shown otherwise. And in an as-applied challenge, Mr. Powers bears the burden of demonstrating that the statutes are unconstitutional as applied to him by clear and convincing proof. Now, he is attempting to do that by challenging the bind-over decision, which is an improper backhanded means of challenging the bind-over itself. Because keep in mind that bind-over decision was not part of the beginning of this appeal. It was not part of the notice of appeal. It was not part of the docketing statement. So it has not been properly appealed. But regardless, getting to that bind-over, it is also well established, getting to the questions that Judge Callahan had, it is well established in Ohio law that especially in civil or quasi-civil cases such as this one, that a court speaks through its journal entries and that the pronouncements that it makes in the transcript are not what this court is going to review. In other words, what the juvenile judge said during the bind-over proceeding in this case is not the sine qua non of its eventual decision to bind Mr. Powers over to the adult court. It was not necessarily, and did not necessarily have to be, a check-the-boxes decision as counsel suggests. And there was ample evidence in the record that would call Mr. Powers' amenability to rehabilitation within any period of time into question. I do not read the opinion of the expert witness as saying that if we only had a year, we could have rehabilitated him. Not when the same expert was questioning whether he would be willing to follow up with treatment and said that he may have an antisocial personality disorder. And personality disorders, as the court is aware, are very hard to treat. That he has an inability to discern between right and wrong, a complete disregard for the consequences of his actions, either the consequences to other people or even to himself, has ongoing or was having ongoing substance abuse problems even while he was residing in what was termed a sober house. And he was displaying, even at age 21, extreme impulsivity and immaturity. And so the question then that was at least implied was that there might not be any period of time in which he could be rehabilitated in the Department of Youth Services. So the state's position is that this does not constitute clear and convincing evidence to say that the statutes with the judicial gloss that has been applied to them are unconstitutional as applied to Mr. Powers. And I understand that I have a little bit of time remaining. I would welcome the court's questions, and without those, I would otherwise rest upon the briefs, and the state would ask this court to affirm.
I do have a question. Opposing counsel relies on, or seems to rely on, or one of the factors made is the second time back in juvenile court, trying to keep the procedure correct here, was given a new case number.
Yes.
Is it the circumstances of what happened that is ruling? Is it the date of the case number, the age of the defendant? What's controlling here?
Your Honor, I would say that it is the circumstances that control here. The juvenile court, yes, gave it a new case number, It is, however, the same case. And its previous action obviously was void ab initio, to dismiss the previous case. Could it and arguably should it have been brought under the same old case number from 2019? That would have made a much clearer record for this court and for all of the parties. However, it is the same case. And arguably, Mr. Powers was apprehended, or still remained apprehended in 2019. That was his initial apprehension. So I guess what I'm trying to say is I don't think it's material or dispositive that we have a 2020 case number in the juvenile court.
Thank you.
Thank you, Counsel.
Thank you.
Attorney Gill, you have 5 minutes for
Thank you. Mayor, I just want to use this time to make a couple of brief clarifications based off of what opposing counsel had brought up in argument, and one of those being, just to be clear, the appellant's position is that it is the juvenile court that lacked subject matter jurisdiction over Jacob in the second case number. That flows through final disposition in the adult case. Not questioning whether or not once it was bound over, it's the initial jurisdiction of juvenile court that is at issue. And I would also just like to point out for the attention, I know that opposing counsel mentioned that the bind over was not part of the original appeal because it was not attached to the docketing statement, but I believe that that's an incorrect statement. No, it was not attached to the docketing statement, but the reality is when the adult court assigns appellate counsel, we are not advised that it was a bind over case and do not obtain that information until we start to dig in. Once discovered, I immediately requested transcripts. I'm sure the court is aware, and I apologize I wasn't prepared for this, but I do have case law that I could cite that a bind over is not a final appealable order until final disposition in the adult court. So there is no other point in time when that portion of this case could have been addressed by this court. And with that, I would rest on my brief.
Thank you both for very recent presentations today. Court will take the matter under advisement, but you will issue a written decision which will be mailed to all parties to this appeal as well as posted on the Ohio Supreme Court website.